Hello, everyone. My name is Devin Barry, and welcome to the latest edition of Thompson Hine's Environmental Laws Podcast. That's LAWS, stands for Land, Air, Water, and Safety. That was the first test for me because I commonly forget what the acronym is, but it distinguishes us from all the other environmental laws podcasts out there. And so today what we're going to be talking about, I'm joined by one of my colleagues. We've had the occasion of really digging into something that's probably been cluttering a lot of listeners' email boxes and in general just news feeds of the Loper decision. And if you haven't heard of the Loper decision, you will hear about it very soon. We'll be walking through, a few of the details and, talk through a little bit of the significance, but we're going to also try to keep this fairly practical too. So again, my name is Devin Barry. I'm a partner in the Cleveland office of Thompson Hine. I dabble in most areas of environmental law, but I tend to specialize in Clean Air Act regulations and anything falling under the Clean Air Act. And I'm joined by my colleague, Aren Olson. I'm going to kick it over to Aren. Thanks for joining and agreeing to talk through this with me today.
Yeah, excited to be here, Devin. My name is Aren Olson, as Devin indicated. I am an associate in the Columbus, Ohio office of Thompson Hine, and my practice focuses also on a wide variety of matters. I have a litigation background, so I find myself in enforcement actions and the like, and also I like to specialize in Clean Water Act work.
All right, excellent. Well, let's dive right in. So we try to make this as succinct as possible. As I mentioned, we're going to be talking about the Loper decision. It's a Supreme Court decision that was decided about 3 weeks ago, I believe. Has a really big impact on really all areas of regulatory law, but obviously being in the environmental realm, we're going to primarily be talking about that as it relates to EPA regulations. So really before going into Loper, I was hoping, Aren, that you could walk us through the predecessor of Loper, really what Loper's all centered around, which is the Chevron decision. Can you give us a little bit of background on what Chevron is to get us going here?
Of course. And to set the stage here, I'm going to bring us back in time to your 7th or 8th grade American history class, where we learned about the 3 branches of government: the legislative branch, or Congress, which makes the laws; the judicial branch, or the courts, which interprets them; and the last is the executive branch, which enforces the laws. And just, by the way, by the executive, I don't just mean the president or police officers. I mean also any agencies that report to the president. So we're talking EPA, among other agencies that also are part of the executive branch. And with that in mind, let's turn to Chevron, because what Chevron really was a way of understanding how all of these different branches of government work together to implement laws. It said, look, we know that technically speaking, the judicial branch interprets the laws and the executive branch enforces them, but in the real world, it's not always quite that simple. Congress passes a lot of ambiguous laws, and when the executive branch has to enforce those ambiguous laws, some interpretation also has to happen as a part of it. And what Chevron essentially said was, look, this is intentional. If the legislative branch leaves an ambiguity in a law, then the executive should have some say or discretion in how to resolve that. And in line with that, what Chevron really did, the really important part of Chevron, is it said that courts must defer to agency interpretations of ambiguous statutes so long as they're reasonable. And by the way, Chevron said this was particularly appropriate a lot of the times because Congress passes some really complex laws. And Chevron thought, it often makes sense to have agencies who employ scientists and experts figure out how those laws should apply in hyper-technical settings. So that's kind of the overview of Chevron there.
So it's kind of like, in other words, boiling it down, basically, if EPA has a interpretation of a law and a regulated entity has an interpretation of the law, then under Chevron, assuming it's ambiguous, EPA is going to win 9 out of 10 times.
Yeah, as long as their interpretation is within the realm of reason. They've got a finger on the scale, right? in that situation. So yeah, that's Chevron in a nutshell. And that kind of brings us to today and the real thing we're discussing, which is Loper. And I mean, Devin, can you walk us through it? What does the Loper decision do to Chevron deference?
Well, I can boil down the 130 plus pages of Loper into a very succinct statement. It overruled the Supreme Court decision in Chevron. Chevron deference no longer exists. And I'm not one for citing Supreme Court language in these things, but I did think one of these lines was pretty funny in that the Supreme Court, or Justice Roberts ultimately says, Chevron is a decaying husk with bold pretensions. I mean, it just sounds kind of like I don't know, a fight behind a school or something like that on, they're really going to town on their real opinions on Chevron. So after the Loper decision, what it ultimately says is that when you have these ambiguous laws, courts should not defer to agency interpretations. It has no bearing at all. It is completely, again, going back to the separation of powers. You're talking about interpretation of law, and that's the sole jurisdiction of the courts.
Yeah, and I mean, let's dig a little deeper there. You said Chevron's overruled and Chevron deference is gone. So what specifically does that mean? I mean, do courts have to listen at all to agencies anymore?
Well, they do, and that's still the caution, I think. I know we've talked a little bit about it when this first came out, that everyone was going to see this decision and draw some pretty bold conclusions. But there is deference still, and the case is clear on questions of fact. So EPA still has, if they're making a finding of fact, then courts must still defer to them in that ultimate, that finding that the agency is making. But I mean, that's just it's just fodder for future cases, because at the end of the day, a lot of times the questions between a finding of fact and a finding of law is razor thin. And it's going to be really hard to distinguish what is a fact. And of course, that's what agencies like EPA will argue. And obviously, petitioners in these cases will typically argue, no, it's a question of law. So that's a dispute for another day.
And there can also still be like explicit delegations too, right?
Absolutely. Yeah, that's a great point.
Yeah. And I mean, so Chevron is gone. Some types of deference remain, but not with respect to what we've discussed. And like, what happened to all the cases decided under Chevron? Because Chevron was decided back in the 1980s, and a bunch of cases were passed, right, using Chevron deference. And can you give us any insight about what happened with respect to those?
Well, this is the big distinction between what the court says in its opinion and practically what will happen in real life. So the court went out of its way to include a lot of analysis to say, yes, all of these decisions were decided under Chevron. And yes, we're overruling it, dead husk and all of that. Mm-hmm. But they also said that the prior decisions remain good law and that you may continue to ultimately rely on them. But that right there there's a fundamental issue with that, in that if you have a rule that was passed back in the day, basically Chevron deference was applied, so therefore it's got this far-reaching impact. I have to believe that folks are going to be revisiting those cases now if the issues are important enough to, pick that scab and go back and reopen the case.
Yeah, absolutely agreed.
So I think we did a good job there of trying to run through 40, 50 years of history in a very quick periods. But let's turn now to more practical aspect of there are a lot of really significant rules that have been passed under the current administration, specifically by EPA. I'm sure others, but that's our world. And so I wanted to talk about some of those rules and how Loper may or may not ultimately impact them. And so we're going to walk through briefly a couple of developments under the water side and the air side, since those are our babies. But again, the Loper will have a much broader impact. So starting with the water side, Aren, I wanted to try to go back to, one of the things that I'm slightly familiar with is the Waters of the United States developments with EPA and their rules. And, that's probably the depth of my knowledge on waters of the United States. So I think it would be good for you if you could give some background on what that terminology means and some of the recent developments leading up to, and then what happens after Loper.
Absolutely. And so Waters of the United States, and it's called WOTUS for short. So I'll just say WOTUS throughout here. It's a critically important term in the water world because what it does is it defines what waters are regulated by the Clean Water Act, a federal statute. So boiling it all down, if a water qualifies as a WOTUS, it's regulated. And if it doesn't, it's not. EPA issues regulations defining what waters are WOTUSs. And I will tell you that these things are constantly subject to challenge. And if you're thinking, why would I ever care how the term WOTUS is defined and why would I ever challenge that in court? Let me just give you a brief example. Let's say you're Joe Blow, you work hard, you save up, you buy a patch of land, you think to yourself, I'm going to build a house on this, I've earned it. But as you go to start construction, you realize you've got a problem. Why? Well, because your land's a little soggy. It's located kind of close to a ditch, and that ditch eventually, through a series of tributaries, feeds its way into a local lake. Now, you might not think that's very important, but what if under the EPA regulations, they say that's sufficient for your land to be a WOTUS, and you can't do any work at your land until you go through an expensive permitting process? I mean, the question is that right? Right?
Right.
And the funny thing is the Supreme Court recently considered a question just like this in a case called Sackett, and it essentially said no. It closely analyzed the Clean Water Act's text, looks at its legislative history and case law, thought about arguments advanced by EPA and other parties, and it eventually concluded that EPA's attempt to regulate, these types of remote things like soggy lands may not be within the scope of that was intended by the Clean Water Act. In other words, it concluded that the agency's interpretation of this ambiguous term was wrong. And to bring this all back to Loper, I think the interesting thing about the Sackett decision is that it gives us sort of some insight, right, into how Clean Water Act regulations are going to be looked at in a post-Loper world, because it was the same Supreme Court, right, that issued Sackett, has eventually went on to issue Loper. And you can bet that at least some of them might have been thinking about a world after Chevron deference. So the way I see it is the way Loper could impact Clean Water Act stuff is it could require courts to, instead of deferring to reasonable agency interpretations of terms like WOTUS, to take a closer look, to think for themselves whether the Clean Water Act's language, history, and case law support the interpretation, and decide for themselves, whether the action proposed by EPA aligns with the statute. They're still going to need to pay and should pay attention to, expertise when it's appropriate to do so. And they, could still have to give deference to things like factual findings. But I think it's going to be a lot more of a court-involved process moving forward, where, as we talked about earlier, EPA's thumb is just no longer on the scale.
And I think one of the important things you said there too, just as a side note, is it is the same court that decided Loper. It is the same court that was kind of at the center of some of the other things that we're going to be talking about. And this is just kind of the tip of the iceberg. So I think you could do an entire podcast on kind of the monumental impact of this current Supreme Court's decisions on environmental law in particular, because you really just have to look back at each of these decisions and see that common thread for each one, even though they're different areas of law, but a very common thread on how they're going to be viewing these types of regulatory interpretations.
Absolutely. And speaking of that common thread, I mean, this is a perfect transition to the Clean Air Act world. I mean, Devin, in your field, in your expertise, I mean, where do you see Loper potentially impacting Clean Air Act regulation?
Well, and I think it could be a lot of different areas, but I'm going to mention two briefly that are, I think, the most recent ones. And one is, everyone's been seeing probably for a decade now of EPA attempting to regulate greenhouse gases from utilities. That's not a new story, but And years ago, ultimately, a court decision came down saying they had the right to regulate greenhouse gases, but having the right and then actually having the legal mechanism or the law is a very different thing. So really what you've been having for a decade is a fight over whether the Clean Air Act has the right mechanisms to be able to control greenhouse gases in the way that EPA has been proposing to do so. And I don't have time to go through all the various rules that have come up and have been withdrawn or have ultimately been rejected by the Supreme Court. But right now, earlier this year, their EPA did issue a new greenhouse gas rule for utilities, natural gas and coal-fired utilities, which would require carbon sequestration as a form of control, where they'd have to essentially inject carbon dioxide into the ground as a form of control. And that's very different. It's a very different look, obviously, than putting something at the end of your stack to control the emissions coming out of it. And it's a different pollutant. So that creates a pretty huge question. And really, in very short form, what's going on is that it's almost as if EPA is really trying to either force utilities to change the fuel sources that they're using, in other words, go to renewable energy, or to make it so difficult for utilities to use those old forms of energy that if they continue to, they will be going out of business. So it's this paradigm, and obviously a huge issue for the U.S. And it's, as far as where it stands right now, it's very salient in that the rules that I mentioned were ultimately and have been challenged by a bunch of states and interest groups in the DC Circuit. Well, one of the things they had requested was a stay of that rule, which the DC Circuit rejected last Friday. So I think you'll be seeing that stay being requested by the Supreme Court next. And going back to the previous statements, what Supreme Court is it? The very same Supreme Court that we keep mentioning. So as far as what the impact of Loper is, I think you're going to have there's a very good chance it's going to have a real impact, because in my mind, when you go back to that, is there a question of law or fact? Does the Clean Air Act allow EPA to regulate greenhouse gas emissions in the way that they're proposing? That is absolutely a question of law, and it's ultimately going to implicate Loper. Now, switching speeds, that's one of the big developments and probably the biggest development. The other one is somewhat related in that you have something called the Good Neighbor Rule. The Good Neighbor Rule, boiling it down very quickly, is ultimately Clean Air Act says that if you're an upstream state, your emissions are going to go over state lines. If they go over state lines and they impact a downstream state's ability to comply with the federal standards, then the upstream state needs to take certain actions. Well, the federal government ultimately thought that the state's plans to comply with this provision weren't meeting the requirements, so they were imposing their own federal plan. And that would have imposed certain emission limitations, control devices, et cetera. So ultimately, states challenged that. And again, what you see that happened in the DC Circuit. The DC Circuit rejected a stay that had been requested last year. And so now you have the Supreme Court, again, the same Supreme Court, listening to the arguments for the Good Neighbor Rule and a stay for the same. And the day before Loper was decided, they made a decision on the Good Neighbor Rule and decided to stay this rule. So this rule is now being challenged as well and is being stayed. So I bring this up because that's a situation in which you have a pre-Loper decision by the Supreme Court, but now it's going to be decided in a post-Loper world. And so it doesn't take a lot of a big jump of faith to determine that the Supreme Court that we keep mentioning is going to certainly be scrutinizing this law. And I should mention that a stay does indicate that the Supreme Court thinks there's some validity to these arguments and that there's a good chance of success. So these are two ones that I won't say are absolutely on the chopping block, but they are certainly going to be in the news in the post-Loper world. So hopefully I think I could keep going on those for a while. Hopefully it wasn't too boring, but I want to try to wrap this up. I think 20 minutes is just about right for a podcast. So let's try to pull it, bring it on home on really, we've talked about Loper on what it is. We've talked about air and water, and obviously it's a much broader impact. Aren, I'm going to put the heavy burden on you. Can you really try to boil down, in your words, what do you think the most immediate most immediate impact of Loper is versus what we may see play out longer term?
Absolutely. I think the most immediate impact of this decision will be on the bigger matters currently working their way through the court systems. Right now, there's a coalition of states that are challenging EPA's definition of WOTUS as overbroad. Certainly, Loper will be talked about and considered by the courts looking at that challenge. And as you just mentioned, in the air world, we've got a bunch of different lawsuits as well challenging EPA regulations under the Clean Air Act. Certainly, and especially with the recent attention the Supreme Court itself has paid to this area, courts are going to be looking close at what Loper means for these decisions, and you're going to see it have a real immediate and tangible impact there. And, with respect to other matters that more directly impact businesses like notices of violation, enforcement actions, etc., I think the impact is going to be more case by case. It's not going to be a silver bullet in every situation, and it's going to take some time for the full implications of this Loper decision to shake out in the courts. I will say, however, that it's going to be another arrow in the quiver of parties subject to enforcement disputes, and one with the potential to significantly strengthen their key arguments.
I think that's excellent. Couldn't have said it better myself.
Well, thank you.
Well, I appreciate everybody listening in to this podcast. Again, as we've said, probably 10 times now, this is a very recent issue, very broad issue. We'll probably be talking about this several more times throughout the year, and you're likely to see some significant new interpretations as courts take this on and parties take this on and start applying it to the real world. So thank you for joining us, and please tune in to our next Environmental Laws podcast, and have a great day.
Yeah, thank you.